Good morning, everybody. So welcome back to the legal discussion today. We take a report from Institute of Intellectual Property and Competition for October 2021. The first question of preliminary observation is, it should be noted as preliminary point that the need for uniform application of community law and the principle of equality require that where provision of community make no express reference to the law of member states. For the purpose of determining their meaning and scope, as is the case of Article 2 of Directive 2001, must normally be given an autonomous and uniform interpretation through the community. In the case C245 Senna, ECR, and case 306 SHA. Though consideration are particularly important with respect to Directive 2001 in the light of the wording of recital 6 and 21 in the preamble of that directive. Consequently, the Australian government cannot successfully contend that it is for the member state to provide the definition of concept of reproduction in part in Article 2 of Directive 2001, see that effect with respect to the concept of public and refer to Article 3 of the same directive. HGIE paragraph 31. The first question. By its first question, the National Court asked especially whether the concept of reproduction right in part in the meaning of Directive 2001 is to be interpreted as the meaning that is encompassed the storing and subsequent printing out on paper of a text extract consisting of 11 words. It is clear that Directive 2001/29 does not define the concept of either reproduction or reproduction in part. In those circumstances, the concept must be defined having regard to the wording and the context of Article 2, whether the reference to them is to be found, and in the light of both the overall objective of that directive and international law, see that effect HGAI paragraph 34 and 35 and the case law cited. Article 2 of Directive 2001 provide that authors have the exclusive right to authorize or prohibit reproduction in whole or in part in their work. Is follow that protection of the work right to authorize and prohibit reproduction is intended to cover work. It is moreover apparent from the general scheme of the Berne Convention, in particular Article 2 and 8, that the protection of certain subject matter as artistic or literary work presupposes that are intellectual creation. Similarly, under Article 1 of Directive 31 and Directive 96 and 6 Directive 26, works such as computer program, database, and photogram are protected by copyright only if they are original, in the sense that they are their author on intellectual creation. In establishing a harmonized legal framework for copyright, Directive 2001/29 is based on the sample principle, as evident by recital 4, 9, and 11 and 20 in the preamble thereto. In those circumstances, copyright within the meaning of Article 2 of Directive 2001 is liable to apply only in relation to a subject matter, which is original in the sense that it is its author on intellectual creation. As regards the part of work, it should be borne in mind that there is nothing in Directive 2001/29 or any other relevant directive indicating that the parts are to be treated any differently from the work at whole. It follows that they are protected by copyright in as such they share the originality of the whole work. In the light of the consideration referred to in paragraph 37 of this judgment, the various parts of work thus enjoy protection under Article 2 directive, provided that they contain elements which are the expression of intellectual creation of the author of the work. With respect to the scope of such protection of a work, this follows from recital 9 to 11 in the preamble to Directive 2001/29 that its main objective is to introduce a high level of protection, in particular for authors to enable them to receive an appropriate reward for their work, including at the time of reproduction of those works, in order to be able to pursue their creative and artistic work. Similarly, recital 21 in the preamble of Directive 21 require that the act covered by the right of reproduction be construed broadly. That requirement of broad definition of the act is moreover also be found in the wording of Article 2 of that directive, which use expression such as direct or indirect, temporary or permanent by meaning, and in any form. Consequently, the protection conferred by Article 2 of Directive 2001/29 must be given a broad interpretation. As regards newspaper article, their author on intellectual creation, referred to in paragraph 37 of this judgment, is evident clearly from the form, the manner in which the subject is presented, and the linguistic expression. In the man proceeding, moreover, is its common ground that newspaper articles as such are literary work covered by Directive 21/29. Regarding the element of such work covered by the protection, it should be observed that they consist of words which, considered in isolation, are not as such intellectual creation of the work who employ them. It is only through the choice, sequence, and combination of those words that the author may express his creativity in an original manner and achieve a result which is an intellectual creation. So words as such do not therefore constitute element covered by the protection. That being so, given the requirement of broad interpretation, the scope of protection conferred by Article 2 of Directive 2001, the possibility may not be ruled out that certain isolation sentence and even certain part of sentence in the text in question may be suitable for conveying to the reader the original publication, such as newspaper article, by communicating that reader an element which is in itself the expression of intellectual creation of author of that article. Such sentences, part of sentence are therefore liable to come within the scope of protection under Article 2 of that directive. In the light of those considerations, the reproduction of extract of protected words, which, like those that issue the main proceeding, comprise 11 consecutive words, therefore is such to constitute reproduction in part of the meaning in Article 2 of Directive 2001, if that extract contains an element of work which, as such, expresses author on intellectual creation. It is for the national court to make this determination. It must be remembered also that the data capture process used by InfoPath allow for the reproduction of multiple extracts of protected work. This process reproduce an extract of 11 words each time, and such words appear in the relevant work, and moreover, often operate using a number of such words because some client asks InfoPath to draw up, summarize based on a number of criteria. So in doing so, that process increases the likelihood that InfoPath will make reproduction in part within the meaning of Article 2 article. Because the cumulative effect of those extracts may lead to the reconstitution of lengthy fragments, which are liable to reflect the originality of the work in question, which the result that they contain a number of elements which are such as to express the intellectual creation of author of that work. In the light of foregoing, the answer to the first question is that an act occurring during data capture process, which consists of storing an extract of protected work comprising 11 words and printing out that extract, is such to come within the concept of reproduction in part of the meaning of Article 2 directive. If the elements thus reproduced are the expression of intellectual creation of their author, and it's for national court to make this determination. If the act of issue, the main proceeding to come within the concept of reproduction in part of protected work within meaning Article 2. So that directive makes it clear that such reproduction may not be made without the consent of relevant author, unless that reproduction satisfies the condition laid down by Article 5 of that directive. In that context, by question 2 to 12, the referring court asks essentially whether acts of reproduction occurring during data capture process, such as that issue in the main proceeding, satisfy the condition laid out in Article 5 directive, and therefore whether that process may carry out without the consent of the relevant right holder, since it is used to draft, summarize a newspaper article and consists of scanning the article in their entirety to produce a digital file storing a stack of 11 words and then printing out as extract. On Article 5 directive, an act of reproduction may be exempted from the reproduction right provided in Article 2, therefore, only if it fulfills 5 conditions, that is, the act is temporary, is transient or incidental, which is an integral or essential part of technological process. The sole purpose of that process is to enable a transmission in a network between the third party by an intermediary of a lawful use of a work of protected subject matter, and the act have no independent economic significance. So it must be borne in mind that no condition are commutative, in the sense that non-compliance with anyone of them will lead to the act of reproduction not being exempted pursuant to Article 5 from the production right provided after the directive. For this interpretation of each bill condition, in turn, it should be borne in mind that according to the settled case law, the provision of the directive with derogate from general principle established by the directive must be interpreted strictly. You can see the copper, commission, and span. This holds true for the exemption provided in Article 5 Directive 2001, which is a derogation of the general principle established of that directive, namely requirement for authorization from a right holder for any reproduction of protected work. This is more so given that exemption must be interpreted in light of Article 5 of Directive 2001, which that exemption should be applied only in certain special cases which do not conflict with the normal exploitation of work or other subject matter and do not unreasonably prejudice legitimate interests of the right holder. So in accordance with the recital 4, 6, and 21 of preamble of directive, the condition laid down in Article 5 thereof must also be interpreted in the light of the need for legal certainty for author with regard to the protection of their work. In the present case, InfoPad claimed first that the act of reproduction at issue in the main proceeding fulfill conditions relating to transient nature, since they are deleted and the end of electronic search process. The court find in light of the third condition referred to in paragraph 54 of this judgment that a contemporary and transient act of reproduction is intended to be enable the completion of technological process in which it forms an integral and essential part. In those circumstances, given the principle set out in paragraph 57 and 58 of this judgment, those acts of reproduction must not exceed what is necessary for the proper completion of that technological process. The legal certainty for the right holder further requires that storage and deletion of the reproduction not be dependent on the discretionary human intervention, particularly by the user of protected work. There is no guarantee that in such cases the person concerned with actually delete the reproduction created, or in any event that he will delete it once its existence is no longer justified by its function or enabling the completion of technological process. So this finding is supported by recital 33 of the preamble directive 2001 with list As example of the characteristic of the act referred to Article 5, thereof, acts which enable browsing as well as acts of caching to take place, including those which enable transmission system to function efficiently. Such acts are by definition created and deleted automatically and without human intervention. So, in the light of foregoing, the court find that an act can be have to be transient within a minimum second condition let out Article 5 only if its duration is limited to what is necessary for the proper completion of technological process in question. It's being understood that process must be automated. So that is delete without human intervention once its function and enabling the completion such as processes come to an end. In a main proceeding, the possibility cannot be ruled out at the outset that in the first two acts of reproduction is issued in the proceeding, namely the creation of tube file and tests resulting from conversion to tube file, may be held to be transient as long as they are deleted automatically from the computer memory. Regarding a third act of reproduction, namely the storing of a text extract of 11 words, the evidence made to the court does not permit an assessment of whether the technological process is automatic, with the result that the file deleted promptly and without human intervention from computer memory. It is for national court to assess whether the deletion of that file is dependent on the will of the user of the reproduction, and whether there is a risk that the file may remain stored once the function of enabling completion of the technological process has come to an end. It is common ground, however, that by the last of reproduction in data capture process, in purpose in making a reproduction outside the sphere of computer technology, which is bringing out a file containing extract of 11 words and thus reproduce the extract on the paper medium. Once a reproduction has been affixed onto such a medium, it disappears only where the paper itself is destroyed. Moreover, since a data capture process is apparently not likely itself to destroy that medium, the deletion of that reproduction is entirely dependent on the will of the user of that process. It is not at all certain that they will want to dispose of the reproduction, which means that there is a risk that the reproduction will remain in existence for a longer period, and according to the user need. In those circumstances, the court finds that the last act of data capture process at issue is the main proceeding, during which info path bring out the extract of 11 words is not a transient act within the meaning of Article 5 Directive 2001. There, moreover, nothing in the case file submitted to the court, and nor had it been pleaded that such act is liable to be incidental in nature. It follows from the foregoing that act does not fulfill the second condition laid down in Article 5 of Directive 2001. Accordingly, such as act cannot be exempted from the reproduction right to provide for Article 2. Therefore, it follows that data capture process at issue in the main proceeding cannot be carried out without consent of the right holder, and consequently, it is not necessary to consider whether the four acts which make up that process fulfill the other condition laid out in Article 5. Consequently, the answer to question 212 is that the act of printing out an extract of 11 words during the data capture process, such as that issue in the main proceeding. does not fulfill the condition of being transient in nature as required by Article 5 of the directive. Therefore, the process cannot be carried out without the consent of relevant right holder. So the question 13. In the live answer given to 212 is not necessary to answer the question 13. All right. So, since the proceeding for the party to the main proceeding each step in action, pending before the national court, the decision on cause in matter for that court, courts incur in submitting observation to the court other than the cause of the whole party are not recoverable. On the ground, the court hereby rules an act occurring during the data capture process, which consists of storing an extract of a protected work comprising 11 words and printing out as extract, is such as to come within the concept of reproduction, in part within the meaning Article 2 of the directive, on the harmonization of certain aspects of copyright and related rights in the information society, if the element thus reproduce the expression of the intellectual creation of their author, this is for the national court to make this determination. The act of printing out an extract of 11 words during data capture process, such as that issue in the main proceeding, does not fulfill the condition of being transient in nature of acquired by Article 5 directive, and therefore that process cannot be carried out without the consent of the relevant right holder. So that's the all meaning of the case, and very, very interesting when the European court, they will have some guidance on everything, and that really, really matter. So thank you again for your listening, and if you have any questions, just give it a shout. We'll take a report from Institute of Intellectual Property and Competition on 4 October 2021. Thank you, and see you again.